Today is Judgment Day. Jennifer Abel, come to the front, please. Yes, girl. Yes, queen. Yes, boss. Slay. There is no one happier than me when I read the absolute slay, the absolute lick back, the absolute boss move to Stephanie motherfucking Jones by Jen Abel today than me. Okay? Let's get into it. Welcome back to this channel. My name is Mandy Magnan. I am a writer, producer, and director here in Toronto, as well as a movie reviewer, pop culture, and your YouTube commentator for everything It Ends With Never. We're diving right in because, yes, today is Summary Judgment Day. We were expecting it, of course, from Wayfair, and Blake Lively's camp said that they may also, whatever. Those things haven't been submitted yet into the court. But what dropped today by Jennifer Abel has the world shook for a reason. And I know there are two women right now who are racking their brains trying to figure out their next move. And that is Blake Lively and Stephanie motherfucking Jones. Jones, you thought you were going to get out of this? Really? Okay. If you're ready, I'm ready. Grab your emotional support lip gloss because we are getting into it straight away. You are in frame with Mandy Magnan. If you've been following this channel, you know that my boot has been on Stephanie motherfucking Jones's neck this whole time because we are only here because of that woman, okay? What she did, No. She not only turned her back on her clients, Wayfair, when she produced all of Jen Abel's contents of her phone to Blake Lively on August 21st, but she also completely destroyed Jen Abel's life while doing so. And they thought, Blake Lively and Stephanie motherfucking Jones really thought they were going to get away with it. Well, today has come. And Jen Abel has spoken with one of the most brilliant boss moves so far in this case. And now let's just get it over with, Judge Lyman. Let Jen Abel go, okay? Because if anyone's going to be paying anything to Blake Lively, it's going to be her bestie who she's been colluding with this whole time. Stephanie motherfucking Jones. Yes. It's a good day. It's a good day. Now, there are a couple of lawsuits going on, so let's just do a quick recap. Yeah, okay. Wayfair was a client of Stephanie Jones. Jones Works for a long time. Jen Abel was the go-to person on that account. In August, when everything started blowing up around the movie premiere of It Ends With Us, Jen Abel, alongside Stephanie Jones, were the PR people. They then hired Melissa Nathan, even though Jones didn't want to. She doesn't like Melissa Nathan. They went ahead, Wayfair decided for themselves and hired Melissa Nathan for the crisis manager. Everything kind of went astray, went a little wild. Jones was losing her marbles. She walked Jennifer Abel out of the building. Okay, after trying the entire month to get into her phone, took her phone that day, took the contents out of her phone, and then handed it over to the op, Blake Lively. Now, Jennifer Abel in the Jones versus Abel case, not the Lively versus Wayfair case, which she is in both of them. Last week when she re-amended her complaint against Jones and Jones Works, gave us a lot of new information, including that there are now conversations and text messages that were produced that prove that Jones and Lively were working together for a month before the fake lawsuit was created through Van Zandt, Blake Lively's inactive company, in order to require a sham subpoena to get otherwise illegal text messages to use not only in the CRD complaint, but in the infamous BS story produced by the New York Times. And now today, Jen Abel is at it again. And what she's basically saying is, I was an employee, Your Honor. Okay, so if anything that Blake Lively is trying to get out of me needs to go through my employer, Stephanie Jones. Yes, now The indemnification, of course, Jones has been fighting in the Jones versus Abel case since the beginning, and then Jones has also now tried to sue just Jennifer Abel. Jennifer Abel is fighting back. It's a whole big mess in both of the cases, but today, you can't argue the facts, and you can't argue the law, okay? And it's just so wild because I think what was happening in the last couple months, which we've all seen in the court docket, is Blake Lively crashing out. Sanctions, subpoenas, sanctions, letters, motions, blah, 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 like going and going and going and going. And everyone was saying, where is Wayfair? What are Wayfair doing? Why aren't they fighting back? Why aren't they doing this? Why aren't they doing that? And I truly think what was happening is every time Blake Lively was pushing and pushing and pushing, and we all know now that most of the stuff that she was fighting for was misleading, to say the least, right? And I think what was happening is Wayfair's lawyers was like, keep calm, don't worry, let it go, let them. Let's get into it. Let's pull up the memorandum from Jennifer Abel that was filed. Let's do it. Third-party plaintiff Jennifer Abel respectfully submits this memorandum of law in support of her motion for conditional summary judgment against third-party defendant Jones Works LLC on her second cause of action for common law indemnification. What she says here is that even though this might be too soon, we're asking you for a conditional summary judgment so that even if at the end of trial, for example, money is rewarded to Blake Lively on behalf of the Wayfair defendants on any of them, let's substitute Jennifer Abel with Stephanie Jones. So you know that $500-600 million Blake Lively is looking for? Open your pocketbook, okay, Jones? Open it up, because you're going to have to pay somehow for what you did. Abel was employed by Jones Works to render public relations services to his clients, such as Justin Baldoni and Wayfair Studios, collectively the Wayfair clients. At Jones Works' direction, Abel performed public relations activities for the Wayfair clients, including in connection with the film It Ends With Us. In late July 2024, early August 2024, public commentary circulated concerning purported on-set strife between Baldoni and the film's co-star, plaintiff Blake Lively. Abel and other Jones Works employees discussed how to garner positive publicity and to minimize negative publicity for the Wayfair clients, as was within Abel's scope of employment with Jones Works. In breach of Jones Works' contractual and fiduciary duties to the Wayfair clients, Jones Works Chief Executive Officer Stephanie motherfucking Jones inexplicitly and covertly advised Lively and the Wayfair's clients' public relations activities. Lively then caused her entity, Van Zandt Inc., to commence a frivolous lawsuit in New York State Court against John Doe's, devoid of any reference to the Wayfair clients or Abel. Jones Works participated in the hoax orchestrated by Lively by generously complying with a knowingly invalid subpoena from Van Zandt. So Jones Works knew that it was a sham subpoena. She literally orchestrated it. Stephanie Jones and Blake Lively were working together, and there is now evidence that they were talking with each other for over a month before the fake lawsuit through Van Zandt was actually filed. She knew it was an invalid subpoena, and yet she still went along with it, which we all knew. But I mean, yeah, you ladies didn't think you were going to get caught, right? You really thought, what? They were just going to settle with you immediately after the New York Times story and this was all going to go away and you were going to wipe your hands clean of this? Because 2025 is the year that what happens in the dark is coming to light. And I am so happy Wayfair fought back, Jennifer Abel fought back, because now we really, really see the dark, dark side of Hollywood. And Blake Lively, thank you for that. The invalid subpoena from Van Zandt, which sought the Wayfair clients and Abel's communications, and which any other recipient thereof would have moved to quash. Based upon these communications, Lively manufactured a claim against Abel for allegedly aiding and abetting retaliation, when in truth, Abel merely engaged in standard public relations activities. Abel's actions at issue herein were all undertaken as a JonesWorks employee within the scope of her employment and were foreseeable by and known to JonesWorks. Therefore, under well-established New York law, Abel is entitled to common law indemnification from JonesWorks, regardless of whether Jones realized at the time Jones betrayed her then clients, the Wayfair clients, that her unwavering alliance with Lively resulted in JonesWorks' own potential liability. That's my favorite line of the whole thing. That's my favorite section. It's in red. Let's just read it one more time. Therefore, under well-established New York law, Abel is entitled to common law indemnification from JonesWorks, regardless of whether Jones realized at the time Jones betrayed her then clients, the Wayfair clients, that her unwavering alliance with Lively resulted in JonesWorks' own potential liability. Statement of facts. JonesWorks hires Abel. Founded by Jones, the firm's current chief executive officer, JonesWorks provides inter alia public relations services to its clients. On or about July 9th, 2020, JonesWorks hired Abel, a publicist, as vice president. As a condition of her employment, Abel executed a non-disclosure and intellectual property rights and non-solicitation agreement, the 2020 employment agreement. Under the new terms of the 2020 employment agreement, JonesWorks hired Abel as an at-will employee. Abel further agreed during the term of her employment that she would work exclusively for JonesWorks, providing no services to any other entity in the public relations industry, media communications, marketing, branding, or talent management business, or any other business without JonesWorks' prior written approval. Approximately 16 months later, on or about November 22, 2021, JonesWorks and Abel entered into a modified employment agreement, the 2021 employment agreement. Per the terms of the 2021 employment agreement, Abel agreed to serve as vice president of talent. Abel's employment required that she devote all her business time to JonesWorks. The Wayfair clients retained JonesWorks. In or around 2018, a couple of years before JonesWorks hired Abel, Baldoni retained JonesWorks to provide him with public relations services. Thereafter, Wayfair, a production studio founded by Baldoni and others, retained JonesWorks for public relations services. On or about May 6, 2020, Wayfair entered into an agreement with JonesWorks for JonesWorks to serve as its exclusive PR counsel. Under the term of the Wayfair agreement, JonesWorks was tasked with providing strategic communication services, including assist in developing, writing, and updating communication materials related to all press outreach, such as biographies, media kits, boilerplates, press releases, and key messaging. Advise on any marketing and campaign strategies to ensure brand messaging is consistent, opportunities maximized, and the strongest press angles aligned. Conduct media monitoring and competitor tracking for industry press, and conduct regular check-on calls surrounding the status of Wayfair studio projects, events, and news. At her deposition, Jones, in her capacity as JonesWorks CEO, testified that, redacted. Specifically, Jones also testified that, redacted. In exchange for JonesWorks' personalized and bespoke services, Wayfair and Baldoni collectively agreed to pay JonesWorks $25,000 per month in addition to other expenses and fees. Now, I already did the math, y'all. If someone was paying someone $25,000 a month from 2018 to 2025, that means they paid them $2,400,000 in or about. Justin Baldoni and Wayfair has already given Stephanie motherfucking Jones $2.5 million for their services. And this is how she does them. This is how she does them. Give me $2.5 million. I won't do you wrong. Okay? You know what I'm saying? I'm on your side till the end. Under the terms of the Wayfair agreement, the initial term of the agreement would last 1 year. Following the 1-year term, the Wayfair agreement would automatically renew for additional 1-year periods unless terminated. Following its retention, JonesWorks, redacted, JonesWorks also set up email distribution lists to help service the Wayfair clients. Additionally, as part of its retention, JonesWorks assigned Abel to serve as the primary point person for the Wayfair clients working out of JonesWorks' LA office. Lively's claims against Abel stem exclusively from her employment for JonesWorks. Throughout the summer of 2024, consistent with the Wayfair agreement and its role as exclusive PR counsel, JonesWorks provided a wide range of public relations services to the Wayfair clients, including in connection with the premiere of the film. During that time period, and more importantly, within the scope of her employment for JonesWorks, Abel performed PR services for the Wayfair clients. A number of those activities now serve as the basis of Lively's claims, as defined herein against Abel, as detailed below. On July 24, 2024, Abel advised Jones that, redacted. Jones responded by redacted. So I don't know what's going on there. Thereafter, and based upon Abel's recommendation, Wayfair hired the agency group PR LLC to assist JonesWorks with crisis management. On July 31st, 2024, Abel texted Jamie Heath and Mitz Tozkovic of Wayfair about a conversation that she had with an independent journalist concerning the exclusion of Baldoni from film-related promotions, and that such journalist was willing to publish a story on Lively's misconduct. Abel never followed up on the matter or referred to the journalist to anyone else, and the story was never published. On August 2nd, 2024, a representative at TAG sent Abel a scenario planning document referencing an objective to protect the reputation of the Wayfair clients in the lead up, during, and following the premiere of the film and related goals. The scenario planning document was shared with Abel because she was a JonesWorks employee responsible for providing public relations services to the Wayfair clients. On August 5th, 2024, Abel notified Baldoni that Sony, the co-producer of the film, had an issue with the word friction being used in his press interviews about the on-set relationship between Baldoni and Lively. Abel proposed the word challenged as a compromise to downplay the social media speculation of an on-set feud and to highlight that as director of the film, Baldoni successfully brought all people together to create something beautiful in the film. On August 7th, 2024, Abel exchanged certain text messages with JonesWorks employees Matthew Mitchell and TAG employees Melissa Nathan, Katie Case, and Brianna Kozlow about an online narrative concerning Baldoni and Lively's separate promotion of the film, as opposed to both being present. On August 7th, 2024, Case sent Heath and Abel at her JonesWorks email address an email referring to social and digital mitigation and remediation and public narratives concerning Baldoni and Wayfair. The email was sent to Abel because she was a JonesWorks employee providing public relations services to the Wayfair clients. On August 8th, 2024, Abel sent a text message to her JonesWorks co-employee Mitchell and TAG employees Nathan and Case concerning taking note of or flagging negative public commentary about Baldoni was a key part of Abel's duty as a JonesWorks employee performing PR relations for its clients. On August 9th, 2024, Abel exchanged text messages with Nathan concerning articles about a rift or feud between Baldoni and Lively, as well as other potential media coverage of the situation. On August 10th, 2024, Abel exchanged text messages with Heath, Mitchell, Nathan, and Case concerning a Hollywood Reporter article and TikTok videos related to Lively and or Baldoni. The TikTok video from May 17th, 2023, included within the text change, shows Baldoni and Lively in a pleasant atmosphere on the set of the film. The Hollywood Reporter article discusses why it was important for Baldoni to make a movie about domestic violence. On August 11th, 2024, and in her capacity as a JonesWorks employee, Abel advised Wayfair via text messages about redacted. On August 13th, 2024, Abel exchanged text messages with Heath, Baldoni, Mitchell, Case, Kozlow, and Nathan concerning a TikTok video praising Baldoni and another video criticizing Lively for her marketing of the film in a manner insensitive to domestic violence victims. On August 15th, 2024, Abel exchanged text messages with Heath, Baldoni, Mitchell, Case, Coslow, and Nathan concerning the positive public comments made. On August 18th, 2024, Abel exchanged text messages with Heath, Baldoni, Mitchell, Nathan, and Coslow concerning TikTok videos related to the film. The TikTok video from August 17th, 2024 called the film one of the best movies ever made and said the film touched on domestic violence in the best possible way. JonesWorks profited from the foregoing work performed by Abel, receiving its monthly $25,000 fee from the Wayfair clients. Interesting that, she had nothing to do with it, but she was still collecting that money. She was still collecting that check, y'all. Abel's employment with JonesWorks ended on August 21st, 2024. Abel never published, planted, or pitched any negative content about Lively, nor boosted or amplified any negative content about Lively. Lively's lawsuit against Abel. On July 30th, 2025, Lively filed her second amended complaint in which she asserted claims against Abel for aiding and abetting harassment and retaliation in violation of California's Fair Employment and Housing Act, FEHA, false light invasion of privacy, and civil conspiracy. According to the second amended complaint, Nathan, her company Tag, and Abel allegedly perpetrated a retaliation scheme against Miss Lively, including via the amplifying of negative content about Miss Lively. The pleading further alleges that Nathan, Tag, and Abel aided and abetted the discriminatory conduct of defendants It Ends With Us Movie LLC, Wayfair, Baldoni, and Heath, including but not limited to by participating in the above described coordinated astroturfing campaign to discredit and bury Miss Lively. Abel denies Lively's allegations and claims. In her third amended responses and objections to Abel's second set of interrogatories, Lively purports to identify the redacted. So I'm sure she mentioned some videos or articles or something that she alleges was by Abel. In her interrogatory responses, Lively further alleges that Abel, and then it's redacted. So I'm sure she's alleging what she believes Abel did or the news articles or whatever. Abel again denies Lively's assertions in her interrogatory responses. Moreover, each of the specific instances identified in Lively's interrogatory responses consists of public relation activities performed as part of Abel's employment with JonesWorks. As discussed above in detail, the activities performed by Abel from July 2024 through August 2024 were within the scope of her employment with JonesWorks. This makes JonesWorks responsible for any potential vicarious liability to Abel for work performed during the course of her employment with JonesWorks. Legal standard. Summary judgment is appropriate where the movement shows that there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law. In response, the non-moving party must then set out specific facts showing a genuine issue of material fact for trial. A genuine issue of material fact exists only when there is sufficient evidence favoring the non-moving party, such as a reasonable jury could return a verdict in his favor. Only disputes over facts that might affect the outcome of the suit under the governing law will preclude a grant of summary judgment. The non-movement must do more than simply show that there is some metaphysical doubt as to the material facts. The non-moving party must come forward with specific facts showing that there is a genuine issue for trial. A party may not rely on mere speculation or conjecture as to the true nature of the facts to overcome a motion for summary judgment. Equally, a party may not defeat summary judgment on inadmissible hearsay. Only admissible evidence need to be considered by the trial court in ruling on a motion for summary judgment. A party cannot rely on inadmissible hearsay in opposing a motion for summary judgment. So where's your evidence, y'all? Where's your evidence? Summary judgment is the time to put up or shut up. Argument. Abel is entitled to conditional summary judgment. Jonesworks cannot escape its obligation to indemnify its employee, Abel, for the work she performed during the course of her employment. These circumstances warrant the issuance of conditional summary judgment in favor of Abel, even though the court has not issued a judgment in the underlying action. The Declaratory Judgment Act provides that in a case of actual controversy within its jurisdiction, any court of the United States may declare the rights and other legal relations of any interested party seeking such declaration, whether or not further relief is or could be sought. The Act confers a discretion on the courts rather than an absolute right upon the litigation. This court has issued declaratory relief where no losses have yet occurred, because clarifying whether a party had a duty to indemnify another party was beneficial not only to those parties, but to plaintiff in the underlying action, who will benefit from knowing who exactly is financially liable if she prevails. It is well established that an indemnified party can obtain conditional summary judgment on an indemnification claim as to liability even before a judgment on or settlement to the underlying claim. Finding it serves the interest of justice and judicial economy in affording the indemnity the earliest possible determination as to the extent to which he may expect to be reimbursed. Conditional summary judgment is appropriate here even when the judgment has yet to be rendered or paid in the main action, since it serves the interest of justice and judicial economy in affording the indemnity, who is Jennifer Abel, the earliest possible determination as to the extent to which he may expect to be reimbursed. As discussed above, Lively's claims rest entirely on Abel's actions undertaken during the course of her employment for Jonesworks, thereby entitling Abel to common law indemnification from her employer, Jonesworks. Rather than holding Abel's claims in limbo, the court should grant Abel conditional summary judgment on her second cause of action for common law indemnification. Yes, it should. Alternatively, in the event the court deems this motion premature because no liability determination has been made as to Lively's claims against Abel, Abel respectfully requests that the court hold the motion in abeyance until such time. New York common law requires Jonesworks to indemnify Abel. You can't go against the law, right? In her second cause of action, Abel seeks indemnification under common law. A federal court sitting in diversity must apply the choice of law rules of the state in which it sits. Accordingly, courts in this district apply New York choice of law rules. Jonesworks herself contends that New York law applies to Abel's common law indemnification claim. For purposes of this motion and reserving all rights with respect to her other claims, Abel agrees. Where the parties agree that New York law controls, this is sufficient to establish choice of law. Common law or implied indemnification is a quasi-contract doctrine rooted in principles of equity and fairness conceptually related to restitution. Implied or common law indemnification recognizes that a person who, in whole or in part, has discharged a duty which is owed by him, but which, as between himself and another, should have been discharged by the other, is entitled to indemnity. And a party who has itself actually participated to some degree in the wrongdoing cannot receive the benefit of the doctrine. Like, Stephanie Jones can't say that she was the head person on it, come back and try to beg Wayfair to stay. She was attached to all the emails, the text messages saying that she was there the whole time, and then say, oh yeah, but also, no. You can't have it both ways, girl. Common law indemnity will generally be available in favor of one who is held responsible solely by operation of law because of his relation to the actual wrongdoing. Thus, if an employee is held liable for following the instructions of an employer who is vicariously responsible for those actions and whose instructions the employee was required to follow, that employee is entitled to indemnification from the person who gave the instruction. Under the doctrine of respondent superior in New York, an employer may be vicariously liable for the tortious acts of its employees only if those acts were committed in furtherance of the employer's business and within the scope of employment. Which obviously what Jennifer Abel did was the entire point of her business at Jonesworks and completely within the scope of the employment at Jonesworks. As detailed above, the alleged conduct that forms the basis of Lively's claims against Abel consists of public relations activities on behalf of the Wayfair clients during the time in which they were Jonesworks' clients, all within the scope of Abel's employment, and any such conduct was undertaken at Jonesworks' direction. In sum, the record firmly establishes Wayfair and Baldoni retained Jonesworks to provide public relations services for them. Jonesworks employed Abel to render those services. And Jonesworks knew of and directed Abel's public relations activities for Wayfair and Baldoni, including garnering positive publicity and eliminating or minimizing negative publicity for them. Jonesworks provided the Wayfair clients with a wide range of services, including but not limited to crisis management to public relations. Then they have some stuff where Jones testified, okay? This necessarily included providing advice, counsel, and public relations support surrounding the premiere of the film. Furthermore, as discussed above, each of the purported acts which form the basis of Lively's claims against Abel consist of public relations activity, not only within the scope of Abel's employment for Jonesworks, but were also part and parcel of Jonesworks' obligation to the Wayfair clients. In other words, Jonesworks lacks any legitimate, much less cogent basis upon which to deny responsibility for Abel's activities. Jones herself knew of Abel's actions, providing supervision and direction. The record further establishes A. Jones knew Abel was working with Baldoni on his press tour. B. Jones knew Jonesworks employees such as Abel monitored social media activity concerning Baldoni in the film, a standard practice. C. Jones knew Abel and other Jonesworks employees interacted with the press handling inquiries and public relations issues. And D. Jones knew Wayfair had retained TAG to provide crisis management advice and services. Jones herself even provided the Wayfair clients with a strategy to handle publicity. In fact, even after Abel's employment ended, Jonesworks continued to represent both Wayfair and Baldoni until at least August 30th, 2024. So Jennifer Abel was walked out of the building on the 21st, but Jonesworks, you kept working with Wayfair through the rest of August. So how can you now say that you had no idea what was going on? Jonesworks has not only declined to defend Abel, but has denied any obligation to do so, going so far as to move to dismiss her claim. Decision on Jonesworks' motion to dismiss. Jonesworks further separately sued Abel based upon false allegations that Abel's public relations work went far beyond the legitimate scope of Abel's employment. Therefore, Abel is entitled to common law indemnification from Jonesworks in connection with plaintiff's claims. For these reasons, the court should grant Jennifer Abel conditional summary judgment against Jonesworks on the second cause of action in her amended third-party complaint. Let's go! Ochre. Yeah, let's just pull Stephanie Jones in here, okay? Let's just, you're not going anywhere. You started this mess. You guys really thought you were going to do something. Filing fake lawsuits, sham subpoenas, literally turning on your clients, turning on your ex-employee, doing all of this because Blake Lively, the queen couldn't handle 2 weeks of bad press and Jones couldn't handle another client leaving her. Wow. So this comes also with a declaration. There's also a Rule 56.1 that's been filed and text messages between Jennifer Abel and Melissa Nathan. Let's look at the text message because you already know an unsealed text change is going to be fire. This text change is only between Melissa Nathan and Jennifer Abel. So they're just talking about some article that just came out, what I'm hearing. Jennifer Abel says, thank God. So apparently Tom Rothman is speaking to Leslie to get Blake to cut the shit. Yeah, cut it out, girl. And now this was on August 9th. I think we can get through this if we get that New York Post piece killed and Leslie agrees to a truce. Melissa Nathan, Jen, we can get through anything. Then Melissa Nathan says something is redacted. Jennifer Abel says, shut the F up. Melissa Nathan says, good Lord, I'll be there in 15 minutes. Can you speak then? Jennifer Abel, yes. And now we have a text message from James. Y'all remember James Vituska, who said one thing, then did another thing, then did another thing, then said another thing, then came. Okay, James. So now this is a text that they received from that James from the Daily Mail. We have learned that Justin Baldoni caused issues on the set of It Ends With Us and that he clashed with many cast members as well as Colleen Hoover. Sources have told us that the women on set felt he was borderline abusive, unprofessional, and unapologetic, and that he failed to consider Blake's character's perspective. Okay, first of all, who does Blake think she is that she thinks that her perspective matters? You are a hired actor. The director does not need to take your perspective. I don't know who Blake thinks or thought she was, but yeah, as an actor, you can say to your director, this line doesn't really feel natural for the character because of ABC. Oh, you know what? I don't think the character would actually do this because ABC. And then the director and the writers can get together and be like, oh, she kind of has a point there. Let's change it. Or they're like, no, we already thought about that and this is why we're doing it. Or like, thank you for that, but let's continue. They don't have to take your perspective, period. Okay? The script was already written. Just that. Like, the amount of ego that Blake Lively had coming onto this project is one of the things that irritates me the most and is so insulting as an actress who has been trying for so long to even try to even do a short film with the character that was given to Lively, like Lily Bloom, with anything like that. Like, it's just so... it's frustrating that we're continually making the wrong people famous and giving the wrong people art and stories, because this is just, it's just, to me, it's disgusting and it's heartbreaking, honestly, because I know so many talented women that would have slayed this part. I digress. Back to James, shall we? We are also told that parts of this script needed to be rewritten as a result, which he took personally. The cast is currently not talking about this because they do not want to take away from their promotional work or the film's release. Many feel Justin's acting was undoubtedly phenomenal and he could receive award nods, but there are concerns he could defend his actions with his style of acting, which is method. Please let me know if you would like to comment, either on or off record. First of all, Justin Baldoni isn't a method actor. He talked about how his acting coach, his therapist, all of these things that he did, all of the training and the work that led up to being able to play Ryle, and the dark places he needed to go and how that wasn't easy for him. It's not method acting. We have Blake Lively, on the other hand, who didn't even read the book. So, you know, whatever. Jennifer Abel just got this from the text from James Frantuska. Melissa Nathan, I'll call him. Jennifer Abel, damn, want me to do anything? Melissa Nathan, this stemmed from what happened yesterday. I'll tell you on the phone how I know now I know James really well. Wow. And then I'll call you. LOL. Okay, Jesus. Melissa Nathan, because Leslie herself called the mail after Stephanie, who is denying it, called the mail. Wow. Okay. Can you chat in 5? Yes. At breakfast, but yes. Call me when you have a second, please. And then they talk about the Hollywood Reporter article. Reading. Then there's a Daily Mail article that came out with the Blake Lively versus Justin Baldoni feud. Jennifer Abel, is it horrible to say I don't think it's that bad? Melissa Nathan, no, because I know what we're watching for. So all things considered, it looks like trash and gossip. Jennifer Abel, it looks like a plant from Blake's camp trying to steer the narrative. Melissa Nathan, well, I mean, Jen Abel, I can tell you've done a lot of work here. Nothing about being unsafe, fat comments, sexual, thank effing God. Melissa Nathan, that's all I care about. The other stuff is just nonsense. And honestly, the money the movie is making is effing great for you guys. Let's just keep steering it that way. And you take this effing client and never talk to her again. I swear to God. Obviously talking about Stephanie motherfucking Jones. Jen Abel, exactly. Do we still need to worry about the New York Post? Melissa Nathan, she also just needs time off for herself. If I'm just being mindful of humanity for a second, she needs to just stop, because obviously there is something as a human being she is doing that is affecting herself mentally. On with my sister now, who works at the New York Post. But also, like, F her. Baha'i needs to be out, and mostly the misogynistic swap that one word. We are crushing it on Reddit from Jed. I'm good now. This is done. Jen Abel, LOL. Melissa Nathan, she put me on hold, so waiting for her. Say some prayers for us, Justin. Oh my God. Say some prayers for us, Justin. Jen Abel, oof. FYI, Stephanie is likely calling Leslie to clear her name about calling the Daily Mail. Unbelievable. Tell her not to answer. This is crazy. Melissa Nathan, send me screenshots, can you? Jennifer Abel, what one? Nathan, just the one saying she's calling Daily Mail, just so I have. And then we have Stephanie Jones text here. What does it say? Let me pull it up bigger for y'all. Stephanie Jones to Jen Abel and Wayfair Studios. Lillian has been nice and fixed things for us in the past. I can give her a call. This is nothing burger. And then from Lillian, last word for Lillian. She's been very nice in the past, so we will get this fixed. Then there's some messages here. Hi, I'm a reporter and I'm currently working on a story. So it was about the story. So she's saying that she'll get it fixed. Melissa Nathan, I feel better about New York Post. Me too. She said she will not return that call, which now we know is Leslie Sloan, because we've already seen those text messages where Melissa Nathan talks to Leslie Sloan and is like, hey, Jones is going to call you, try to apologize. And Leslie Sloan was like, no, thank you. She's too much drama. Abel, blessed be. Nathan, when you come back to Los Angeles, we are definitely having our dinner. I hope Jamie can see how bloody hard you are working. Oh, what is really interesting is that the comments, especially on an outlet like this, are pro him. Abel, yep. Nathan, it's fine, honestly. Then she pulls up. Now page 6 is running the same article about Blake Lively being uncomfortable. Who's that coming from? Lively, hello. Nathan was driving, sorry. I knew she would keep uncomfortable. Abel, so are we in the clear now? Did we survive? Nathan, we survived. I actually think because of all the noise and all of the stories pretty much saying the same thing that I kind of got lost in a really weird way, if you know what I mean. And also now we have Leslie 100% telling us they are not placing anything else. Anything else. Abel, no, I totally agree. Oh, thank God. Nathan, and you've had no more requests. All press is so overwhelming. We've confused people. So much mixed messaging. It's actually really funny if you think about it for now. Abel, I've had very few and nothing about the articles, which is wild. Nathan, because it's too much press, so much messaging, it's crazy. Every headline is different. I really think the worst is over. I do think the next few months definitely will be a tiny bit bumpy, but not canceled. Follow me back on IG as I can't message you until you do, and it's rude. People, Elizabeth Rosner just texted me saying, hey, I heard you were helping with Justin. Is there any news you can share with me at all, because it's completely silent everywhere? I'm just going to say I was asleep, but that's really good news to say. I can't talk to any more journalists today. Abel, yes, I had some people text me too, and I just didn't respond. The narrative online is so freaking good, and fans are still sticking up for Justin, and there literally has been no pickup of those 2 articles, which is actually shocking to me. But I see this as a total success, as does Justin. You did such amazing work. Nathan, narrative is crazy good. So did you. Then Abel has something, but it's totally redacted. It says, excuse me, I've been sitting as requested for a while now, and then all of this stuff is redacted. What on earth does this look like to me? She says, LOL, I'm dead. That is so crazy though. Ha ha ha. I didn't even make a photo. I didn't even make the photo big and check. Just saw the bio. I'm dead. That is so funny. I wonder what's in this redacted part. And now I just want to really quickly look at Local Rule 57.1 statement that was also filed by defendant Jennifer Abel. There's just a few things to look at. It kind of just summarizes everything that we read in the memorandum. So does Jennifer Abel's declaration, but I just want to look quickly at a couple of things. I mean, I highlighted so much because it's super relevant, but we kind of already went over it. The memorandum kind of summarizes this. This is just a little bit more just pointed, right? Just fact by fact by fact instead of like storytelling. And it's right here. And this is the contract from Wayfair. So what was involved in their work is press materials, assist in developing, writing, and updating communication materials related to all press outreach, manage media and press communications, interagency programs, advise on any marketing and campaign strategies to ensure brand messaging is consistent, opportunities are maximized, and the strongest press angles aligned. Executive visibility, position and utilize Wayfair Studios' key executives as thought leaders and change agents in the film and television industry. Ongoing proactive outreach, develop a 12-month media and communication strategy to further drive awareness, strategize and execute select film and television project announcements, conduct proactive feature pitching to top-tier print, broadcast, and online media outlets, conduct media monitoring and competitor tracking for industry press, conduct regular check-on-call surrounding the status of Wayfair Studio projects, events, and news, measurement and evaluation. Clip and service media is published. Create monthly clip books and activity reports that detail account activity and media impressions. Create and maintain a media library on behalf of Wayfair Studios. It feels like with their contract, that's exactly what Jennifer Abel was doing. There's a lot more in these articles, like so much redactions about Jones's, right here about Jones Works's deposition. So she testified to a lot of stuff here. So that's going to be very interesting. What we need to know is Jennifer Abel denies Blake Lively's allegations. Abel never published, planted, or pitched any negative content about Blake Lively. Abel never boosted or amplified any negative content about Blake Lively. The pleading further alleges that Nathan, Tag, and Abel aided and abetted the discriminatory conduct of defendants. It ends with us, Wayfair, Baldoni, and Heath, including but not limited to, by participating in the above described coordinated astroturfing campaign to discredit and bury Miss Lively. Abel denies plaintiff's allegations. Abel denies any fault and or responsibility for Blake Lively's claims or the alleged loss or damage incurred by Blake Lively because Abel undertook the actions while employed by and in the course of her employment for Jones Works. Abel did not take any of the actions at issue herein in pursuit of her own interest. Jones Works knew of and foresaw Abel's actions because it directed her to render public relations services to the Wayfair clients. Jones Works had contracted with the Wayfair clients to perform inter alia public related services. And Jones knew that Abel was working with Baldoni on his press tour in connection with the premiere of the film. Dun dun dun! Stephanie Jones, you're in trouble, girl. It starts with Jennifer Abel, and it is going to end with the Wayfair summary judgment. But Judgment Day is here. I mean, I've been saying it ends with Jen Abel because she brought in Van Zandt. She brought in that Jones and Lively were colluding for over a month to create the Van Zandt fake lawsuit. I mean, these people have been working hard to get this case, and this was perfect. They also say how Jones Works actually created an email chain list in order to just, when you email Wayfair about it ends with us, it would go to everyone involved. I mean, Stephanie motherfucking Jones did that. So then how can she come back and say that she didn't know anything was going on? I'm just so happy for Jen Abel. I think this is clean cut. It was to the point. And now we'll see what the judge has to say. If he does allow this to happen and indemnify Jennifer Abel, It would just be the cherry on the top of the cake for us specifically, who have known from the beginning that Jones started all of this, and we wouldn't be here today had she not turned her back on her own clients, on her own employees, in order to just seek revenge. We are here today because there are scorned women who wanted revenge. Revenge is why we're here. Blake Lively wanted it because obviously her maximum effort Ryan Reynolds PR didn't go as well as she had planned. She thought for sure she would be a billionaire like her best friend from It Ends With Us, then selling her alcohol line and then her hair care products during a movie about domestic violence. Yeah, that didn't go so good. So she wanted revenge because she for sure thought that that marketing campaign was going to work. And when it didn't, she needed someone to blame. So why not blame the carpet that you've been stepping on the entire time, which is Wayfair, who she thought she would be able to walk all over yet again, but not this time, Blake Lively. Stephanie motherfucking Jones wanted revenge on Abel for leaving her, as well as taking Wayfair, one of her biggest clients, since everyone else left her too. It's absolutely ridiculous. And now some freaking accountability. I'm psyched about this, okay? Drop your comments. Let me know what you think about the big news today. We're still waiting on summary judgment from Wayfair. I just saw that the Lively people have responded to Jed Wallace's motion to seal some of his deposition. I'm going to get into that in the next video. I will talk to you soon. It's Judgment Day, baby. I love you so much. Talk to you soon. Bye.